On behalf of the University of Chicago, the University of Chicago Alumni Association, and the newly formed LGBT Alumni Club, I'd like to welcome everyone to our event tonight entitled Same-Sex Marriage and Constitutional Law. My name is Greg Darnell, PhD 08 from the Biological Sciences Division, and I'm co-chair of the LGBT Alumni Club with my friend here, Vincenzo Barbetta, in BA 05. First off, I'd like to thank everyone for the wonderful attendance tonight at our inaugural event. We're extremely excited to have such a great turnout, and we would especially like to thank the University of Chicago's Alumni Association for sponsoring this special interest group, which we know will provide a long-lasting and complementary addition to the existing alumni clubs of the university. The goals of the LGBT Alumni Club are to strengthen the bond between the University of Chicago and its LGBT alumni. We also want to create interest in and support for the university, most specifically with regard to LGBT issues. And we want to provide fellowship, support, and service to LGBT alumni. Finally, our goal as an alumni club is to enrich the role played by LGBT alumni in the life and leadership of the U of C. To accomplish these goals, we will need your help and support. We have formed a national steering committee that has been actively meeting and formulating directives, events, and membership. We are also indebted to our wonderful alumni office staff, Maureen Laughlin and Eric Rogers. Could you please stand? These individuals have been a backbone of administrative support for us during this genesis. The LGBT Alumni Club is looking to offer a variety of events to our alumni and the general public, and would like to expand a wide range of programming both here in Chicago and around the globe. We encourage you to check out and sign up on our website at lgbtalumni.uchicago.edu for more information, and we encourage you to share this website with your friends. We also ask that you mark our holiday party that we're going to have on December the 2nd. It will be, the details will be sent out soon via email if you sign up on the website. Again, thank you for coming tonight and sharing with us in this special event. For many alumni, this has been a long-awaited group, and we're excited to bring it to fruition and become long-lasting supporters of our alma mater. Thank you.
Welcome once again to everyone. We're very, very excited about the turnout that we have here tonight for our kickoff event. Kickoff event that will be in 3 parts. We'll begin with our keynote speaker after some well-deserved introductory remarks. We'll move on to the discussion and Q&A part of the event, and then finally the reception outside afterwards. The Q&A discussion portion will be led by Melanie Rowen, an alum both of the college and the law school at the University of Chicago. We're very, very glad that she's with us tonight. During her stay at the law school, Melanie was awarded the Ann Watson Barber Outstanding Service Award. She was also the recipient of the Stonewall Scholarship, which is awarded to the student most likely to further the cause of civil rights for the LGBT community. After she graduated from the law school, Melanie joined as a staff attorney at the National Center for Lesbian Rights in San Francisco. The NCLR was lead counsel for in-re marriage cases, the marriage equality case that was judged favorably by the California Supreme Court on May 15th, 2008. We're very glad to have her with us tonight. We're leveraging the assets of the alums, our esteemed faculty, and also staff this evening. So to give the introductory remarks, please let me introduce the Executive Director of the Alumni Association and Associate Vice President of Alumni and Constituent Relations, Mr. Tim Child, also an alum of the college.
Thanks, Vincenzo. Thanks, Greg. Not an alum of the college, of the Humanities Division and the Business School, but close enough. Thanks. I'm really thrilled to be here for any number of reasons. I'd like to reference the Stonewall Scholarship that Vincenzo mentioned, which was set up at the law school in the mid-'80s by a group of alumni, one of whom, Jim Hormel, later became the first openly gay ambassador from the United States to another country, to Luxembourg. And I think you'll remember the fight over that was led by another alum, John Ashcroft, senator from... I think this is part of what makes Chicago such a great place, is that you get these polar kind of opposites going at each other, and it always makes for an exciting conversation. I arrived at Chicago 25 years ago as a graduate student in English, and I was freshly out of 10 years in a Catholic religious order, and freshly out in other ways as well. I showed up at Chicago, and one of the things that I valued most about arriving on campus was that it was the first time in my adult life I could just be myself because nobody cared that I was gay. And I had not actually had that experience because all anybody cared about is if I could do the work and if I had anything interesting to say. And as long as I could fill those requirements, everything was okay. I had the privilege of trying to set up an alumni association for lesbian and gay alums back in the early 90s, and some of the folks who helped me with that are here. I was out in Los Angeles at the time, and when I talked to the Alumni Association about sponsoring that group, I was told the university really didn't do that for special interest groups. So it did kind of peter out, but as fate would have it, I could paraphrase Mel Brooks here and say it's good to be king, because now that I'm executive director, we do this now. And not only for lesbian and gay alumni, but there's a Chicago Women's Business Group that's very active. Last week we had a sold-out event with the University of Chicago Association of Black Alumni, the first time we've had a group of black alumni organized and getting together and socializing and networking. And, you know, we all know this is important stuff. So I'm really grateful to Greg and Vincenzo and the steering committee for helping put this together, for Maureen and Eric on the staff for helping. And I'd like to actually thank my colleagues, some of my colleagues who are here today as well. Rose Martinelli, who's the Dean of Admissions at the Booth School. I don't know where you're here, Rose. There's Rose back there. David Fithian and his partner, Mike Rodriguez. David, where are you? There you are, the Secretary of the Board of Trustees of the university. David. Bill Michael, his partner, Mark Botello. Bill is the Assistant Vice President, Dean of Students at the university. Suzanne Baker, who's my colleague, Assistant Vice President in the Development Office. I'm pointing these folks out because we really tried to rally the gay mafia tonight for the whole thing. I'm going to stop with the history there because really it means huge amount to me personally as an alum of this institution. Oh, Bert Kohler. My God, Bert. I have to introduce Bert on the faculty. Bert and I were on the board of Horizons when they were talking about building this building, and Bert has been a tireless supporter of gay and lesbian students forever. Just thrilled that you're here too, Bert. Thank you. And of course, the gang from the Center for Gender Studies and the Gay and Lesbian Studies Project, Stuart Michaels, Gina Olson, are here as well. So we did get at least a good chunk of the mafia organized. I'm really thrilled to introduce Martha Nussbaum to you as our speaker tonight. When I was working in the Divinity School at the university, my boss, Clark Gilpin, came in and said he was very excited because the law school and the Divinity School had figured out a way to attract Martha Nussbaum to the university. And it was a huge sense of excitement on her arrival. And I think you all know that she is not only a prodigious scholar and one of the most widely published, widely decorated, do they call it decorations when you get honorary degrees? Widely decorated faculty members at the university who's written a numerous number of books. The one thing I wanted to point out about Martha Nussbaum's work, which matters so much to me, is that the thread running through all of her work is a consistent attention to what matters about human dignity and humanity. And she has been committed to that in her work, both in her writing and the work she's done for women in India and elsewhere. She's been just a tower of liberal strength, a great voice for equality, and it's just such a privilege to have you here at this first event. And thank you for wearing leather, too, because that was just perfect. So with that, Martha Nussbaum.
Thank you all so much, and I'm just so thrilled to be here. I think it's such a wonderful event, and I'm really just honored and tickled to be here. So thank you for inviting me. As I have a book that's coming out in February about sexual orientation and constitutional law, and in the beginning of that, I tell the story of how I first started thinking about this issue of same-sex marriage. And I was a young actress at the time, and I saw suddenly in the theater community people who were able to openly acknowledge their relationships and live out in the open, and that certainly had not been the case. And in fact, I didn't know, at the age of 16, I didn't know that such relationships were really in existence. So it was like me coming out of a certain closet of imposed ignorance into something of curiosity and knowledge, which I still value the theater for. So that was my first beginning of thinking about this issue. And then, much later, just before I came to the University of Chicago, as a young classicist, I was involved as an expert witness in the bench trial of Evans versus Romer. And I won't talk about how it came to be that a classical scholar was asked to testify in that gay rights case. In the question period, you can ask me, but since it doesn't have anything to do with the topic, I won't. But it was very much of a sideshow. But in that trial, I not only saw the urgent importance of the issues, but I also saw the nature of the opposition up close. I was there in the courtroom when Will Perkins, who was testifying against, and trying to articulate why Amendment 2 was a great thing, he was forced to read into evidence some pamphlets that he had circulated during the campaign for the referendum, and they were all filled with horrible appeals to disgust and saying things like gay people eat feces and drink raw blood and so on. So I understood, and then I became curious about the politics of this, and I understood the extent to which this politics was a politics of stigma and disgust. And since in later time and writing about the emotions, I got really interested in writing about disgust. I've actually framed my book around that issue, and it's from disgust to humanity, sexual orientation, and constitutional law. So now I'm just going to talk about marriage, but I'd be happy to talk about any of the other issues in the book in the question period. So what I want to do, just for these few minutes, is to focus on the arguments that are often heard against the legalization of same-sex marriage. And I think there are 5, and I want to try to say why I think that none of them is a good public argument. Now, in each case, I think we have to ask, does the argument really justify the conclusion, or that same-sex marriage should not be legally available, or does it justify some quite different conclusion? And second, whether it's a public argument, by which I mean, is it something that citizens in a pluralistic society can decently put forward in the context of that pluralism to citizens who don't share their own religious convictions, or is it an argument that works only within the confines of a particular religious body? Observant Jews don't think it's good to eat pork, but they typically do not recommend making pork illegal for all citizens. It's just well understood that that's a religious issue, and it's not something that we could decently trot out as a public argument. So that's what I think we have to ask about each of these. All right, so the first one, and it's the one that we hear all the time, says the purpose of marriage is procreation. Now, of course, this sidesteps the fact that lesbians and gays do have children within that relationship, or children from a previous relationship, and so on. But let's just put that to the side for one moment and ask, is it really true? Have we ever thought that marriage is just for procreation? Well, I think it's really obvious that we have not thought that. For the whole history of this country, we've married people known to be sterile, We've married people known to be much too old to have children. And almost more important, we've married people who will clearly never have any kind of sexual intercourse with each other. Deathbed marriages are permitted. And, in a very important Supreme Court case, prisoners serving life terms without the possibility of parole were held to have a fundamental constitutional right to contract a marriage. And the court explicitly says, well, it might turn out that some of these people may eventually be released and get to actually meet this person that they're marrying, but we're not going to focus on that. We're going to focus on the emotional and expressive significance of the marriage. So clearly we don't think that. And if we want to change the whole institution, that's not what these opponents are recommending. Second, they say, oh, well, of course, that may be true, but marriage, marriage is about the protection and rearing of children, and we all know that children do best with a mother and a father. You hear that all the time, and I'm sure Melanie will talk about the propaganda in California. Well, actually, by itself, of course, that just saying it's about the protection of children, again, that wouldn't do because gays and lesbians are raising children all over the place. So they have to rely very heavily on this empirical claim that children do best with one mother and one father. Well, the problem with that one is the facts. Again and again, since the Hawaii court in Bear versus Lewin, where a lot of psychological testimony was heard, it's quite clear that when you frame child welfare neutrally, so that you don't smuggle in any kind of religious notions into the definition of welfare, actually, children do just as well in same-sex relationships as in opposite-sex relationships. So that one is just factually unconvincing. The third one says something like this: to allow people to get married is to confer approval on them. So if we legalize same-sex marriage, what we're doing is legalizing the blessing or sanctifying or the approval of same-sex marriage. And what that means is that if I'm an opponent of same-sex marriage, I'm being forced to approve of or bless something that I actually don't approve of. That's an argument that's actually been made by a very respectable and I would say quite thoughtful law professor, Charles Freud, who used to be Solicitor General of the United States, in a book called Modern Liberty. So this is a heavier one, but I think it's very hard to figure out what he means by this. And if we try to figure out what he really does mean by this, I think it's got to raise Establishment Clause problems. Let's think of Jews and pork again. If a Jew tried to say, well, if you allow the sale of pork to be legal, that forces me to bless or approve of something that I find abhorrent, that would clearly raise an Establishment Clause problem if this person wanted to use that as a reason to ban the sale of pork for all people. And if you look at countries where a religious norm is imposed on all people through public law, you see that that's a country with a religious establishment. For example, the prohibitions on driving on the Sabbath in Israel, and in India, the prohibition on cow slaughter. These represent the fact that a religious group has gotten sufficient political power to constitute itself as either a de jure or de facto establishment. And I think it's clear that our country has chosen not to go in that direction. So that may be an argument that some people someplace may want to go for, but not here and not for us. Fourth argument: traditional marriage is in trouble. Marriages are falling apart all the time. There's a crisis in marriage. So we better just keep to the traditional definition of marriage and somehow save the future of that glorious institution. And this is the kind of thing that was said in the Defense of Marriage Act testimony all the time. And there were speeches after speeches saying this wonderful institution is under threat, so we can't change the definition of it because that would threaten it even more. Now, first, I think we have to ask, is traditional marriage in unusual trouble? I think the problem is that the traditional marriage was not such a blessed and perfect institution, and in particular, it was not perfect for women. women had originally in the 19th century, they had very few options. They couldn't get divorces on grounds of cruelty or neglect and so on. So now women have exit options that they didn't have before. They also have employment options they didn't have before. So women are not sticking around in a marriage that doesn't meet certain standards of equality, and it may be that is the biggest explanation for the rising divorce rate, and a lot of scholars think that. So there may not be a problem, but let's just say, all right, there may be a problem. What would we do about it if we thought that heterosexual marriage is in trouble? What would we sanely and rationally want to do to protect it? Well, lots of sensible things suggest themselves. Marital counseling paid for by the state, employment counseling in this time of economic hardship, drug and alcohol counseling. All of these things have a clear and rational relationship to the preservation of traditional marriage. Keeping other people who want to get married from getting married has no such clear and rational relationship. It's just very hard to see even what people are thinking when they think that somehow stopping those people over there from getting married would help me preserve my marriage. Now, actually, we're getting empirical evidence that helps us because the divorce rates in the states that have legalized same-sex marriage are not, in fact, going up, and I would not have expected them to. Now then, here's the one that really is doing the work, I think, and it's a very sort of indirect and nefarious one, and so we have to take it apart. Namely, the very approval of same-sex marriage somehow sullies or taints or demeans my marriage. Now, here we're moving onto the ground of disgust, I think, and so we want to try to figure out what the argument is that's being made. Now, I think what people purport to be saying is something like this. Well, if the Metropolitan Opera audition started giving prizes to pop singers of the sort who sing on American Idol, that would somehow sully or taint or demean the winners of the Metropolitan Opera auditions. If the Hall of Fame started admitting those baseball players who are known to have used steroids, well, once again, that cheapens or sullies that honor of getting into the Hall of Fame. So the point that they think they're making, I think, is that the recognition of low-level or cheap or non-serious or crooked contenders for an honor sullies that honor. So I think that's what they think they're saying when they talk about how same-sex marriage would defile traditional marriage, when they talk about a defense of marriage, and so on. So what should we say about that? Well, of course, we have to first of all just challenge it on the facts. Same-sex couples are not like inferior singers or cheating athletes, or no more so than are heterosexual couples. There are creeps in all communities. And, but people who want to get married for reasons that are very similar to those of heterosexuals. They want to express love and commitment. They want some of them to gain religious sanctification for their union. They want to get a package of civil benefits. Some of them want to have and raise children. So the existence of some cheaters or bad people among the group of heterosexuals has never stopped the state from marrying heterosexuals. And people do not talk or think this way. I've never heard one person say that the fact that Britney Spears can get married somehow taints my heterosexual marriage because she's a cheap contender for that. But somehow, without knowing anything at all about the same-sex couple next door, they do think that the fact that they can get married cheapens or sullies that marriage. Now, if the proposal were that we should introduce character tests for marriage or have background checks, at least then there would be something like a consistent proposal. But of course, no one is supporting such an intrusive regime. What's clear is that they just do not fret over the way that inferior heterosexuals might sully the institution of marriage or lower its value. And given that they don't worry about this, and given that they certainly don't want to allow a marriage for gays and lesbians who have passed a character test, it's really hard to take this argument at face value. I think that really we can't understand what's going on without thinking about disgust and contamination. The only distinction between unworthy heterosexuals and the class of gays and lesbians that can possibly explain the difference in people's reaction here is that a lot of people still find the sex acts of gays and lesbians disgusting. And I'm afraid this even does include Charles Freud, who says, well, if you're going to think with sympathy about this, you have to not think about sex, because otherwise it would be too difficult. And so nothing short of a primitive idea of stigma and taint can explain the widespread feeling that same-sex marriage is a contamination to straight marriage. So in the end, I think the arguments all boil down to something very primitive and something that's in the ballpark of disgust. And if we're looking for a historical parallel to that, we can find it very easily in the history of views about miscegenation. At the time of Loving versus Virginia in 1967, when the laws against interracial marriage were struck down, 16 states both prohibited and punished, sometimes as a very serious felony, marriage across racial lines. In Virginia, which was a typical example, a marriage across racial lines was a felony punishable by from 1 to 5 years in prison. Well, like same-sex marriages, cross-racial marriages were opposed with a wide range of arguments, but in hindsight, I think we all can see that it was disgust that was at work. It was the same feeling that made people think they can't swim in the same swimming pool with a person of a different race, they can't drink from the same drinking fountain as a person of a different race. I was actually raised by a father from the Deep South who was a practicing lawyer and an extremely educated man, but he actually did believe that if an African-American person drank from a glass in the kitchen, you couldn't wash that glass again. You would have to throw it away. So these deep feelings about what contaminates the body were clearly at the bottom of the ban against miscegenation, and in fact that wasn't even hidden all the time. The Racial Integrity Act of 1924 in Virginia positively proclaimed that ideas of contamination were ubiquitous. Well, what did the law think of that? The Supreme Court concluded that ideas of racial stigma were the only ideas that really supported those laws, whatever people said. They said, quote, "There is patently no legitimate overriding purpose independent of invidious racial discrimination which justifies this classification." And I think we should draw the very same conclusion about the prohibition of same-sex marriage. Irrational ideas of stigma and contamination, the very kind of animus that the Supreme Court recognized in Romer versus Evans as not giving the law even a weak rational basis, is a very powerful force in the support of this opposition. And that's what the Supreme Court of Connecticut very nicely said in October 2008. What they said is, beyond moral disapprobation, gay persons also face virulent homophobia that rests on nothing more than feelings of revulsion toward gay persons and the intimate sexual conduct with which they are associated. Such visceral prejudice is reflected in the large number of hate crimes that are perpetrated against gay persons. The irrational nature of the prejudice directed against gay persons who are ostracized, despised, demonized, and condemned merely for being who they are is entirely different in kind than the prejudice suffered by other groups that have been denied suspect or quasi-suspect class status. And so what they're saying is it's a very deep-seated prejudice, it's deeply irrational, and it cannot be got rid of without a very strong legal work. Well, so I think that that's what these arguments add up to. And we haven't seen any, I think, that could ever supply government with anything like a compelling interest, and I don't even think any of them will even pass the weaker rational basis test, given that they are based on animus. On the other hand, what do we have on the other side? Well, I think the argument in favor of same-sex marriage is very straightforward. If two people want to make a commitment of the marital sort, they should be permitted to do so, because to exclude one class of citizens from the benefits and dignity of that commitment demeans them and insults their human dignity. And I think it is that simple, both as a matter of morality and as a matter of constitutional law.
All right. I'm going to stay down here. Thank you so much, Professor Nussbaum. I have to say, as a double alumni of the college and the law school, it is extremely exciting to me to be up here with Professor Nussbaum. And also, I feel so gratified to have you be working in this area, and all the writing and scholarship that you've done on this, I think, is going to help those of us who are advocates in the field really move forward at a faster pace, and I really mean that specifically about your work. And so I'm very grateful to be here with you today and also to hear you talk about this. And I'm looking forward to your book as well. Let's see. I would like to get to questions, particularly because I think our time is a little bit short. I think it might be useful, though, for me to speak for just a couple of minutes about what I do and what's happening in advocacy on behalf of lesbian, gay, bisexual, and transgender people today, just to give a little bit of a framework for that, and then also maybe to give people some ideas about what they might ask questions about. I think everything that I do as an advocate really relates closely to what Professor Nussbaum is saying about human dignity, and that's kind of why we're all here, why we've all shown up, and everything, all the arguments that we make and all the fights that we have to have all boil down to that basic concept. And it seems fairly obvious, I think, for most LGBT people, but it doesn't seem that obvious to many other people. So that's sort of a building block of advocacy on behalf of LGBT people that many of us take for granted, but you need to make that point over and over again. My name is Melanie Rowen. I'm a staff attorney at the National Center for Lesbian Rights. I'm going to explain a little bit about what my organization does, again, to sort of widen the field of what's going on in advocacy on behalf of LGBT people, and to give some examples of what's happening out there. So my organization, the National Center for Lesbian Rights, we are a national legal nonprofit. Our goal is to further the civil and human rights of LGBT people through public policy advocacy, public education, and impact litigation, particularly. Can I just get a show of hands? How many folks in here are lawyers? Oh, boy. Yeah, a lot of lawyers in the house, but not too many. Not too many. That's my favorite kind of audience, the mixed audience. It's true. Impact litigation, for folks who don't follow legal issues as closely, that's typically defined as appellate level litigation, meaning litigation at higher level courts, not trial courts, that has some sort of outcome that is going to actually change a rule of law that will have an effect in cases other than the one that you're actually litigating. So we typically take cases at the intermediate appellate level or at the state high court level or federal high court level as needed to try to get case law on the books or to strike down statutes that are unconstitutional in order to make things better for LGBT people. And that's what I get to do for my job, and it's totally awesome. I recommend it to everyone. And I guess one other thing that I want to explain about what I do, obviously our most relevant work for purposes of this event was the in re marriage cases litigation. That was the California Supreme Court case that was decided in 2008, which led to the legalization of marriage for same-sex couples for a brief and wonderful period during the summer of 2008. It all came to an end in November of 2008 with Proposition 8, and we were also lead counsel on behalf of same-sex couples and organizations representing LGBT people in the ensuing Proposition 8 litigation, which concluded this past May, with the result that marriage for same-sex couples is still not happening in California at this time. So in addition to the marriage-related work, though, just again to give you an idea of what's going on out there, the work that my organization does is divided into program areas. Some of the stuff that we do is relationship recognition beyond marriage, so domestic partnerships, civil unions, reciprocal beneficiaries in Hawaii, and now designated beneficiaries in Colorado, all of these different ways of working out how do we allocate rights and responsibilities to couples if we're not going to call it marriage. We also do a lot of parenting and family law issues. That's the backbone of my organization. So we do a lot of work on making sure that the relationships of non-biological parents to their children are recognized and remain recognized even after the parents maybe have broken up. We also do a lot of work on behalf of transgender people, making sure that they can maintain custody of their children, and on behalf of the parents of transgender children. We do a lot of immigration work, asylum work, and also policy advocacy. The Uniting American Families Act, some of you may be familiar with. We were involved in the drafting of that bill that would recognize domestic partners in same-sex relationships for purposes of immigration. Although hopefully if we have a DOMA repeal, that could end up not being necessary. We have a youth project. We represent youth in out-of-home care and the foster system and the juvenile justice system. An elder law project, which is sort of my baby. We represent LGBT elders and also try to just do advocacy within the aging community for LGBT people and within the LGBT community on behalf of those of us who are getting older, because a lot of people in the community don't remember that we have older people amongst us. And I would just, in case there's anybody here tonight who is interested in this, I would like to give a shout out to the Center on Halstead, which has actually a groundbreaking program for LGBT seniors in the Chicago community and does amazing work on that. And if that's something you're interested in, I would really encourage you to get involved here with that. We also do employment work. We have a sports project. There's homophobia in sports. I don't know if any of you knew that. This just in, homophobia in sports. And a project called Proyecto Poderoso, which is a collaboration between us and the California Rural Legal Assistance Organization. We represent farm workers in California on LGBT issues. There's a large number of LGBT farm workers, and it's a very sex-segregated form of employment, and there's a lot of discrimination based on sexual orientation and gender identity in that context. So we're working on that. We have 6 attorneys. Most of us are generalists. I'm a generalist. I do a lot of different types of stuff, and I'm happy to talk to people afterwards about all what that entails and what we do. I have an unjust enrichment case out there for the business lawyers that I'm doing right now, and Title IX retaliation, lesbian breakups, you name it, I got it. So that is what I do. Generally. And if you are interested in supporting our work or LGBT impact litigation generally, I'm happy to talk to people about that. Please just come up and talk to me and give me your contact information and ask me questions, and I will tell you all about it. I have to talk about it all day. On to, or back to, some of the things that Professor Nussbaum said. You packed so much content into such a short period of time that it's difficult to know what to pull out, except to keep revolving around this basic concept of human dignity. I think it might be helpful, particularly because we have a lot of non-lawyers in the audience, just to frame things for question time. I'm going to really briefly describe the legal framework that all of this is being litigated in, because I don't think that the news actually explains it all that well a lot of the time, at all. And it came up in some of what you're saying, and the basis of your counter-arguments are that these things have no rational basis, that none of these arguments provide the state with a rational excuse for drawing a line based on sexual orientation in the context of marriage. So the legal framework that comes out of, the rational basis context, for folks, again, who have not attended law school, and why wouldn't you do that? You should all go, everyone. Everyone go today. Normally when the law draws a line of some kind, like any law, it's constitutional if there's a rational basis for it. If somebody can walk into a room and say, you know what, that law would make sense if they were thinking of this when they wrote it, that's the end of the story. It's constitutional. When the law draws a line based on a particular personal characteristic, such as race, national origin, religion, sex, sort of, then if that characteristic is a suspect classification, like those ones I just named, then the state has to show that the law that it made is necessary to further a compelling state interest. So they've got to show they really had a good reason for doing this. And it's a very important reason, and they actually needed to do this in order to accomplish whatever that goal was. And it's very clear. I mean, I think you lay it out without you don't even need to go through why these arguments don't meet that test. They're just patently not meeting that test. So for advocates, actually, a lot of what we're trying to do is just get courts to say that sexual orientation is like race, like national origin, like religion, and in some states and places like sex, say that sexual orientation is one of these classifications that is suspect. So if you're drawing a line based on people being gay, you've got to really show you had a good reason for it. The other piece here is that when the law takes away a fundamental right from anybody, not just based on a suspect classification, but just in general, if the law takes away a fundamental right, again, you need to show that it was necessary to further a compelling state interest. So the other moving piece here is the right to marry a fundamental right, and what do we mean by the right to marry? And I thought in your article that you published in Dissent, I really liked your discussion of what is a marriage? What do we think of when we talk about marriage? And in the California marriage litigation, we spent an inordinate amount of time briefing this issue because the court actually asked us, what do you mean by the right to marry? And we spent so many hours thinking about how do we pack all of this content into a legal argument and also answer the court's other questions and also get out of here on time. And we spent a lot of time on it. The California Supreme Court kind of did it for us in the end. They came back with, we think that the right to marry is the right to form a recognized family with the person of your choosing, which is a really concise and contentful, I think, way to say it. Whatever it means to you to form a family, which means a lot of different things to people, and with the person of your choosing, and then to have the state recognize that. That's what we're seeking. On the other side, right-wing advocates typically say that what we're asking for is a right to same-sex marriage, which then conveniently allows them to say, nobody has a right to same-sex marriage. No one's ever had that. That's crazy. What's a same-sex marriage? You don't have a right to that. And that is specious, very specious, because it's the right to form a... It's an individual right. It's also, the California Supreme Court said, it's also the couple's right, both the couple's right and the person's right at the same time. So we spent a lot of time trying to get the court to that place, that the right to marry was a fundamental right that applied to same-sex couples as well as different-sex couples. And that wasn't actually a large hurdle in our case, but in some states it has been, and some state courts have not accepted that the right is the right to marry, generally, for all of us, rather than this right to same-sex marriage, which is the framing that the right-wing groups have tried to put on it. That framing is dying, I think, particularly as marriage for same-sex couples becomes a reality in many different states. It doesn't seem so crazy anymore to say the right to marry encompasses that, and the phrase right to same-sex marriage sounds weirder and weirder, which is good. So that's the legal framework here. The things that came out of the California litigation that are important today were that the California Supreme Court was the first state high court to acknowledge unequivocally that sexual orientation is in fact, like race, like religion, like national origin, a suspect classification. We've had other state courts who sort of got around that issue. In Connecticut, for example, the state high court found that it didn't meet the rational basis test to deny same-sex couples the opportunity to marry. So they didn't need to consider whether sexual orientation, like race or religion, is a suspect classification. But between the U.S. Supreme Court's decisions in Romer versus Evans and also Lawrence versus Texas, and the California State High Court's decision in intermarriage cases, there's now a growing body of legal authority that sexual orientation you shouldn't be expected to change your sexual orientation, and the law shouldn't be able to shut you out on that basis. So that's sort of what's happening in the legal world on this front in the larger constitutional litigation sense. In the political sense, we're seeing all of these arguments that Professor Nussbaum brings up over and over and over again in our ballot fights, because ballot initiatives are now really one of the big fronts in this war on relationship recognition. But it's also going to be increasingly on non-discrimination generally. We're going to see another wave of attacks from right-wing groups on LGBT people using transgender issues as a wedge to try to get rid of non-discrimination protections. And we'll be seeing these sort of disgust-focused messages over and over again. I think an interesting thing that's happened just in the last decade or so is that right-wing groups have gotten increasingly boxed in just by growing political acceptance of gay people, to having a much more difficult... I mean, for example, the anecdote that you gave about the Romer trial. Nobody would show up in court today and try to argue that gay people eat feces or drink blood, because they would be laughed out of the room and they probably wouldn't get to go to a court again. But the people still want to use that concept. They just have to sort of slide it in under the radar. And the messaging gets more and more sophisticated. And there are some very smart people working on this issue. I think fundamentally they're going to lose because it's a loser, but it is a loser. But a good example a lot of commercials, I'm sure if you've seen them on YouTube or if you live in a jurisdiction that's faced one of these ballot fights, a lot of the commercials will relate to children in a way that seems friendly on the commercial's part, but insidious on the part of the gay people that the commercial is talking about. And it's tricky how this is done. A lot of it relates to what are they going to teach our children in schools. My daughter came home today and said, Mommy, I can marry a princess. That was a specific incident that occurred in the California campaign, a commercial about that. And then there's some stuff that's a little bit more disturbing. There was a commercial that aired in California for a while that didn't kind of make the same headlines that the Mommy, I Can Marry a Princess commercial did, where there was an all-white room and a baby in it with sort of an overtone of purity. Everything was very clean, everything was very spare, there was the baby, and then they showed not the baby, but just one man in the bed, and then it said every child deserves a mother and a father. And that makes you think, who else is in the bed? And where's the baby now? And it's it relates to these concepts without actually coming out and saying, and they eat feces and drink blood. But they want you to remember that. And I think that when we're able to eradicate that type of messaging, the whole thing will be over, because that's pretty much what it has boiled down to, because the rational arguments aren't working for people anymore. So I actually am going to stop talking now, although I had so much more written down. Oh, I have one more thing I want to say before I do that. I think when you talk about what these arguments boil down to, and particularly the one that sticks the most, which is that children will, that accepting same-sex couples into marriage devalues the institution itself. One point on that is the one that Professor Nussbaum mentioned, which is that it defiles the institution somehow, and that goes back to purity. But another point, and this we see again in the ads in particular, and sometimes in briefs in courts, the other point is that children won't understand what marriage is if just anybody can be getting into it all the time and we're redefining that term. The redefinition point comes up again and again, although it doesn't have a lot of content. So if you can redefine marriage, or if anybody can get married, children aren't going to get what marriage is. And I think here, the redefinition point, if you think about what that means, it has to boil down to gender essentialism, because there's no other difference in the definition of marriage from allowing same-sex couples in, other than what is the sex of the people involved. And that point, I think, has not had such a high profile in the public debate about this, but it's worth thinking about, because there's really nothing else that this is about at the end of the day besides sex roles, if children are going to be so confused by who can marry whom. So that was the last thing that I wanted to say, and now I think we should open it up to questions, if people have any. You can go to the mic if you want, but I can also repeat your question.
Why don't you go to the mic? This is better for everyone to hear. Then maybe I'll take the mic from here.
Hi there. I wonder if is this on? Okay. I wonder if you could say a little bit about what arguments you think are ultimately going to result in reversing the Defense of Marriage Act, and also how much difficulty you think is caused by the fact that the President of the United States currently objects to same-sex marriage on religious grounds, and really how much all of this comes down to Establishment Clause issues. So.
Well, yeah, I must say I've been very distressed with my former colleague when he says things like that, because as a professor of constitutional law, he does know that has no bearing on the resolution of a constitutional question. And in fact, of course, it isn't even the official position of the church he belongs to, but that's yet a further complicating factor. So I think that was a campaign maneuver, but I think it is distressing to hear him pull that kind of thing out. He does say he wants the repeal of DOMA, and I think it won't get repealed if he doesn't put the machinery of the administration behind it. But right now, you know, the atmosphere is such that he's getting leapt on from all sides, and I think he's just decided he's got his priorities, and that's not among them right now. You know, you saw what happened, a week and a half ago when he met with the gay groups who had gathered in Washington, and he didn't even refer to the march, which was taking place right beside this more proper meeting. So, you know, he's sidestepping those issues, and I think really there are a lot of good legal arguments that DOMA is unconstitutional. Andy Koppelman, for example, has written very well on this. But I think none of that will do any good politically unless the president really puts his weight behind it. And at that point, I think, you know, most people really would be glad to get rid of it. They just don't want to be the first person. And so there's just got to be a political tipping point, at which point then it becomes fine, and it's the thing you want to do.
I have one small thing to add to that, which is just to clarify that the president actually took a very nuanced position during the campaign, which is a tricky thing to do, and he did it on a lot of issues. But on this one, and we were really feeling this in California because the nuance got lost politically, but what he was saying was, I don't support marriage for same-sex couples in my own personal religious framework, but I also don't think that laws like the Defense of Marriage Act are appropriate, and I think it should be repealed. And, you know, I liked that, but it was definitely ignored on all the mailers that went out in the Prop 8 campaign that were on the yes on Prop 8 side, saying President Obama doesn't support same-sex marriage, so neither should you. Yeah.
Has come out.
Well, I think the first thing to be done is to really make it clear that that's what it is, and then oppose the very powerful legal arguments that say that disgust is a sufficient condition for making something illegal. Obviously, Lord Devlin said that in the 1950s, Fitzjames Stephen, going way back, and more recently, our former colleague Leon Cass, when he was head of the President's Council on Bioethics, said that disgust is a sufficient condition for making human cloning illegal. Well, that's what he was talking about, but if you read his little manifesto, The Wisdom of Repugnance, it is a perfectly general claim that pervasive disgust. Now, he's different from Devlin. I think Devlin's argument is a kind of solidaristic, conservative, Burkean argument that the fabric of society can't be too abruptly torn, and if it is torn, bad things will happen. I think Cassism, it looks like a theological argument. I mean, I think what he's really saying is God has implanted in us this response as a way of steering us against evil. But in any case, whichever version is out there, it's definitely out there. It's being made as a respectable argument. And I think what was great about Romer v. Evans is that the Supreme Court says, oh no, this doesn't give you even the weak rational basis. So I think that's the legal side. How you get rid of it in people, that's a complicated matter. We can sort of see that it's for the most part, it has happened with race. I mean, I just don't think there are very many people exactly like my father who are growing up now, and I think that's great. Now, how did that happen? I think a lot of it is knowing people, going to school with them. So the enforced integration was very important. And I can certainly see, and I'm sure everyone in this room knows families where, when a child comes out or some friend of a child comes out, the attitudes really do change because all of a sudden it's not a demon, but it's a human being that you already knew. So I guess psychologically, I think that is the biggest thing. And the media play their role. I actually think, Will and Grace probably did more good than a lot of things.
I loved Will and Grace. The only thing I was going to say, I sort of assumed that your question was about looking at it from the legal political perspective. The most important question is how do we get voters to change their minds to lessen that reaction enough, or to purposely put a governor on themselves to say, like, I still feel grossed out, but I'm not so sure that it's right for me to vote this way anymore. A practical, I guess, anecdotal backup of the foundation of your question, we had a terrible time in California because a lot of our messaging was these logical arguments. And we thought, and part of that is because it's difficult to nail down what is the culture of California because it's such a diverse state. So an appeal to logic was sort of one of the more general messages that could be created. And it did okay with focus groups, but it really didn't get the voters there to just be like, this is about fairness. We all believe in fairness. This is why this is unfair. Didn't get us there. If you look at what's happening in Maine right now, the Maine campaign is being run on a very different basis, and their response is, Mainers don't discriminate. We all know people who are different. And it's not a logical thing. It's, are you with us? Then you don't discriminate. Which is, it's in the same ballpark, but it's really not the same thing. And I'm hopeful for them with that message.
Well, it's like what the Iowa court did was something like that when they wrote their opinion. Yeah. That is, they used all the traditional fairness arguments, but then there's a lot of stuff about how Iowa has always been in the vanguard of the movement to be different and to protect right. Yeah, it was really, really great, I thought. Awesome. Yeah.
It was all about sex equality in Iowa, which was exciting.
And it was quite interesting that they were actually willing to allow women to practice law while Illinois was still making it illegal. So it was all this stuff that they pulled out.
So you guys shouldn't feel bad about the marriage thing.
I was actually going to ask you to comment about Iowa because I had occasion to experience Iowa, and it was amazing. It was so positive. And everybody there was so cooperative, and everything just went so beautifully. And the ceremony was lovely, and it was grand. And I said to the gentleman who performed the ceremony, who was an appellate court judge, I said, how did this happen in Iowa? And he said, it's a very long story, and I really don't have time to tell it to you now. But he said, I'd be happy to give you the references because it was a very interesting trip that we got here. And I would like your comments, you made a few, but why Iowa of all places?
Well, I think they knew that they had a Democratic majority in both houses of the state legislature, a Democratic governor, and the court was the right court. So the litigators were well primed for who they were dealing with, and they thought this is not going to be a case like California where you're going to have this backlash because of the heavily and the rules, their process. So to get something before the voters requires, a very large supermajority?
Yeah, large, and twice and over the course of 2 years. So there's breaks.
Yeah. But as to the population, I mean, I think probably there is something to this idea that there's a bunch of stiff-necked, independent people who think differently. I mean, I guess the interesting thing would be to comment on the difference between Illinois and Iowa, and I don't think I'll try to comment on this. My former student and glorious campaign person, Jim Madigan, who's running for state senate. Where are you, Jim? Is that you? Yeah, and if elected as a state senator, will be the first openly gay person in the Illinois State Senate. So we must all work for Jim's campaign. But and he was the head of the LGBT group at the law school when he was a law student. So I mean, I know Jim has interesting views on that. I don't know if you want to comment at this point or in this setting about what the reasons are for some of the opposition in Illinois.
Well, sure. I can say that here in Illinois, we do have severe religious opposition. It is the case that the Catholic Conference of Bishops, which is run by our cardinal, sends lobbyists to Springfield and are among the most powerful lobbyists railing against not even a marriage equality piece of legislation, but civil union legislation. So even an attempt to find compromise and common ground by ceding the word marriage and its potential religious components, by trying to sort of set that to the side, is not enough for our opponents. But I actually now just do have a question for the two of you. One of the things we see in all the polling is that all of the younger folks with increasing numbers support marriage equality. So if we did nothing judicially and waited on the democratic process, we're probably going to win. One of the things that I think is a fear, I think Justice Ginsburg has talked about the fact that at the time of Roe versus Wade, states, cities, majority of the population was coming to accept reproductive freedom, and that Roe versus Wade galvanized and energized an anti-choice movement in a way that became destructive and to this day I think is still quite pernicious and very divisive in our society. And so I guess my question to Martha is, given that possibility, why should the gay community take a chance on a constitutional resolution at the federal level, or should we? Or should we wait to do that? And I think it's an open question. It's a difficult question.
I think it is. I mean, I think it would be unfortunate that it would reach the Supreme Court, because this particular Supreme Court would not, I think, deal with it very well, and I think it would produce a backlash. But as to individual states, should they take the legislative route or should they take the judicial route? You know, I think it depends on the state and what their structure is, like Iowa, and what's likely to transpire if the judicial resolution. Sometimes it's easier. I mean, if there are legislators who are intimidated by the lobbyists from the church, as you portray, and so on, they may actually be quite happy if the courts do it, and then they might be quite delighted to have it taken off their shoulders that way, whereas to have to do it themselves means they have to be accountable for it in the next election. So I think in some cases like that, where you think there's powerful opposition from a certain hierarchy, but on the whole the poll numbers show you that there's a lot of support for it, well, that might be a good case for a judicial action.
Yeah, this has been, I mean, you know this better than anybody, but this is, I think, such a fascinating look at the sort of push and pull between these three different fronts of sort of what's happening in legislatures, what's happening in courts, and what's happening in popular opinion. And in some states, California, where you could sneeze and amend the Constitution, like you could wake up in the morning and be like, I'd like to amend the Constitution today, and you will. that these things are out of balance, but they all kind of pull each other forward in different ways. And there's a lot of scholars, especially associated with UC, actually, who have written on this specific topic of how civil rights moves forward in this way. And I mean, we're seeing it in action. I don't have a specific. I don't even have a specific opinion in response to your question, because I just think what happens will happen.
But I think it does look like it's a one direction shift, not like things having to do with the control of women and their bodies, and maybe it's because it's really only about disgust. And the other thing, I mean, sex equality is about very powerful financial and other power interests, and men's control over women, very, very, I think, perhaps more tenacious in the sense that it's less likely to just go out of existence in the next generation. I don't see that happening. I don't know.
Yeah. One other last thing that this makes me think of is this is why actually the schools is such a touchstone thing for both advocates like me and also right-wing groups. This is why a lot of their commercials are about what are they going to teach in schools, because everybody knows that kids increasingly do not care if you're gay or not, and that's very upsetting to some people and very much a relief to the rest of us. And schools are battlegrounds, and individual schools and individual communities are battlegrounds, and whether a GSA gets established at a particular school will have an effect on hundreds of kids. And so all of this type of work comes together to sort of create this process that is eventually going to result in the right outcome, however long it takes.
Hi. Hello. I'm Salim, and I have two questions. One dealing with the discuss issue, and one dealing with the litigation issue. Now, given our current composition of our Supreme Court, I recently read in the Wall Street Journal, many scholars claim that Justice Kennedy doesn't have a judicial philosophy. But recently in the Wall Street Journal, it said that if you couched arguments in libertarianism and international law, you could sway him. So I wanted to know your thoughts on being able to sway Justice Kennedy to the more liberal side of this issue. And on the discussed issue, to what extent do you think some of the advocacy campaign ads and commercials that they ran in California, such as one with two gay males holding hands and reciting a love poem to each other, to what extent do you think that actually dismantled their efforts to turn over Proposition 8? Because I'm thinking of the same issue in
right. No, I mean, I think they did later do a lot of study of the different images and what worked. And as I understand it, came to the conclusion that the most effective images, if you wanted to undo people's resistance to same-sex marriage, were images that showed parents talking about how they wanted their children to be treated, so that the parents, of course, were not themselves gay and lesbian. And so to show these heterosexual parents who care about their children was more effective than showing the gay and lesbian people directly because of this discussed factor. Justice Kennedy, I mean, of course, he is a puzzle to many people because he doesn't make very tight arguments. And so what it is but on this issue, for whatever reason, in both Lawrence and Romer, he's been the one who's been the deciding, not just the deciding vote, but the writer of the majority opinion. And, he has a very strong and quite passionate view about individual liberty in this regard. Now, unfortunately, he writes so unclearly that how far it extends is extremely unclear. So Lawrence, I mean, as you probably know, whether it's the right to intimate sexual choice in a relationship in somebody's home, or is it something much broader? So there are all these, so it's been interpreted different ways by lower courts, because cases like, do you have a right to use a sex toy, have come out different ways in different circuits, both citing his opinion, because his opinion is so unclear as to whether it's the right of the individual to manage that individual's sexuality however that individual wants, or whether it's something much narrower, sort of limited to intimate relationships, perhaps in somebody's home. So it would be nice if it were spelled out a little more clearly. But as to women's issues, he's quite obtuse because he can be gotten at by the most ridiculous propaganda. I mean, if you look at the partial birth abortion opinion that he wrote, he just says, it's been shown that women regret abortions, and so we must protect them from the consequences of their irrationality. And so all this paternalism that's not backed up by any serious evidence, somebody fed him that line and he bought it. But I think for whatever reason, on the gay issue, he really has some very sane and consistent sympathy
Melanie, I wanted to thank you for the tremendous work that you and your colleagues did in California and that you've continued to do. On that front, though, I'm curious what your reaction and what your colleagues' reactions have been to a federal lawsuit filed in California. And I noticed that that hasn't been mentioned, and I think it's a difficult issue. So for someone like you who can actually speak to that, that would be great. And Professor Nussbaum, is there any chance that you can talk your colleague, Judge Posner, into writing a new article about this issue, since he hasn't written on it since '96, retracting that issue of it being a different right, as Melanie mentioned earlier, and perhaps just doing an economic analysis as he does so well, more so than he does any other legal analysis?
Yeah, that would be great. I assume that you're referring to Perry versus Schwarzenegger, which is the federal lawsuit that was filed in California shortly after we got the Proposition 8 decision. I also didn't mention that the Proposition 8 decision held that it was okay for the voters of California to strip a constitutional right from a particular subgroup of Californians, despite the fact that the basis of the court's opinion would mean that Californians could also strip any right from African Americans or from Jewish people. There's no distinction in their opinion between Prop 8 and that kind of decision. Back to Perry. So from my perspective as an advocate at this point, the best thing about the Perry lawsuit is that it was filed by Ted Olson and David Boies. And for folks who are not familiar with Ted Olson in this room, he is an unlikely champion. From the perspective of LGBT people, certainly. On a personal level, obviously, there's no reason to think that he ever didn't like gay people, but I don't think that anybody was expecting a former Solicitor General for the Bush administration or the attorney for George W. Bush in Bush versus Gore to come forward and say that he was outraged by the discrimination that is visited upon gay people by prohibitions on same-sex marriage and that he was ready to fight for it, but that's what he's done. Just the fact that he has impeccable conservative credentials. There's nobody on paper who is more conservative than Ted Olson, I would say. And and then among conservatives, he's one of the most respected conservative legal scholars and advocates in the country. For him to come forward and make this his issue and devote this much of his time to this issue is really heartening, because it really shifts the expectation for who should care about this and what is this really about. And it sort of brings in a whole new family of people, intellectually and then culturally, who are supposed to be angry about this, and maybe now they will be. So that's great. I hope that it comes out well, is the other thing that I can say about it. The timeline on it is going to be very long. Judge Vaughn Walker, who's the Northern District of California judge who has been assigned the case, is known for being an excellent judge. He's extremely smart. He has signaled at every turn so far in this case that he's really interested in building a strong factual record that will show whether there is a reason to exclude same-sex couples from marriage, and the kind of evidence that you're talking about, the procreation evidence and so forth, that's all going to come in, or he's not going to let it in because he's going to say it's not relevant, and regardless, he's going to build a record that is really, I think, because it will be truthful, because it will be accurate, and because it will be detailed and complete, can only be good for our side. So that's another thing to look forward to with that case. And then again, the timeline is going to be really long, so not much else to say about that right now.
About Posner, well, I co-teach with him often, and I can never influence him in any way at all. So, but actually, right now, he's taken a new strategy of turning down a lot more invitations because he thinks he ought to focus on one project at a time, and he's focusing very much on this economic writing about the economic collapse, which I think is some of his best work in recent years, so I wouldn't want to deflect him from that, really. But I just find that it's more difficult to get him to participate in a conference on some topic that usually he would have enjoyed doing 5 or 6 different things. But he's just in a different frame of mind now, and so I think probably not, actually.
Thank you.
So I think we have time for one more question.
In the political debate on this issue, it seems that there's constantly sort of blending of the issue of religious marriage and civil marriage, and there's sort of an assumption that the two are the same. It seems that everyone seems to always talk about religious clerics marrying people and the fear that they will be forced to do that, and I never really hear a distinction and the fact that marriage is in fact a civil issue, that there is such a thing as civil marriage, and religious clerics are given that power by the state. Can you just talk about that?
Yeah, I mean, this is something I could have brought up in my list of arguments, but I think it's so patently silly, this fear, that I didn't bother with that one. I mean, after all, you're quite right that our country, unlike some of the European countries, allows clerics in any church to perform state marriages, but that's always been, as you say, quite distinct from performing a religious marriage. And of course we know that there are many religious denominations that allow and encourage same-sex marriage, including my own Reform Judaism, and that doesn't mean that it counts as a state marriage. It's just that if you are a minister, then that pretty much automatically gives you the right to perform a state marriage, and you can even join an online church, what is it, the Unification Church, and that conveys already the right that if you pay a certain amount and become a minister of that church, you can perform marriages in many states. So it's that kind of dispensation. But of course, those religious people have never been forced to marry people who don't meet the criteria of their own religion. I mean, rabbis are not forced to marry non-Jews. Catholics or priests are not forced to marry people who've been divorced, and so on. My daughter married a non-Jew, and our rabbi, who was not a particularly liberal Reform rabbi, refused to marry them. You know, we don't have any case against him. We just have to go around and find somebody who will marry them, and luckily the cantor agreed. You know, so it's just going to be like that. The religious personnel will have the same latitude they always had to do things by the lights of their own denomination, or even their own particular, as in the case of my daughter, their own particular religious preferences.
Yeah, it's such a common sense point, and I feel like it's a thing that really bugs people who are aware of it, because it's so obvious, and but it really does make a difference to a lot of people who aren't familiar with it, and it is one of the last remaining ways, one of the last remaining buttons that can really be pushed to convince people to vote no on marriage equality issues, because they are worried that would be a step backwards for freedom that they cherish in some way, but they shouldn't be worried about it because it's actually not, that's not the law. But so the solution that we have actually been employing to deal with this in states where we have this opportunity is to write in religious exceptions to laws that establish marriage equality, even though those exceptions are already part of the law. But we just write them in there just to make everybody feel better and know that they're there. And that's actually been a successful tactic in a couple places, and it also works in ballot fights. If the supporters of marriage equality have the opportunity to create the language that is going to be voted on by the voting public, you can put these exceptions in there, and people feel more comfortable vote, and you can work that into the messaging then. And everybody, it's a solution that really works for everybody. It's not some disingenuous tactic. We're actually assuaging people's fears and also following the law, but establishing equality. But we do see it over and over again. The other thing I wanted to say about this point is something that I don't talk about too much about the California litigation because it often seems like a side point, is that we marshaled all of these friend of the court briefs from all of these different groups for all kinds of purposes, making all kinds of arguments. And one of my favorites was a brief by a huge number of religious groups and a huge range from sort of every major religion and then many denominations within those religions, making the argument that it was actually an infringement of their religious freedom to deny them the opportunity to perform state-sanctioned marriages for a subset of their congregants, their same-sex couples who wanted to get married. So here they were saying, we're people of faith, and we actually want to get our people married, and you are not allowing us to do that in the same way that we can do it for our other congregants, and that is offensive, which is one of my favorite arguments out there, because it's great. Excuse me, sorry.
She's